issue is concerned. So let's go with the very last one. It says, Nana Agradaa's 2025 conviction arises from new evidence tied to the 2022 televised schemes separate from her earlier 2021 case. So obviously, the legal prosecution managed to get fresh evidence to support what really got her into trouble somewhere around 2021. Now, joining us on the line this evening live on Newsnight is a private legal practitioner, lawyer Richard Ni Ama. Counsel, good evening. Welcome to Newsnight.
Mr. Speaker, good evening.
Now, from what we are told, there was a mandatory order or pregnancy test by the sitting judge, which of course took Agradaa out of the court for that test to be done. And the question we're asking this evening, though we know is part of the legal proceedings as far as a woman or a female is involved. What if she was pregnant? What would have happened?
Pregnant, the sentence could have been deferred. For example, she would have been allowed to give birth, and then after giving birth, she can go back and continue with the sentence. Or if the offense is such that fine is amenable, then she could have been fined if she was found to be pregnant. The principle of law is that you do not punish an unborn child because the prison is not a conducive place for raising a child. Therefore, whenever a female is about to be sentenced, the judge is duty-bound to confirm whether that female is pregnant or not before handing over a sentence to the female.
And what if, yes, it was confirmed she's pregnant? You just mentioned the sentencing could have been deferred. In that season, does she have or will she have the window for an appeal?
Of course, if whilst the sentence is still waiting, her lawyers decide to appeal, they can. But at that point in time, the question will be, what are you appealing? Because the judge has not told you exactly how many years she or he is going to give you. To appeal, what are you going to appeal exactly? So they would have a challenge in appealing. Now that a sentence has been given to her, they know exactly what they are appealing. So if they are appealing, they can go ahead and appeal. But where the sentence has been deferred and the judge has not told you how many years you are going in for, and you are trying to appeal, I think you have a challenge with appeal.
I see. Now, let's come back to her conviction, the punishment given to her. She was given 15 years in prison with hard labor. Let me first ask, were the charges that was given to her, these charges professed to her, sent to the court, maximum sentencing would have been how many years?
Okay, so when you are looking at defrauding by false pretenses, Section 131 of Act 29 says that whoever defrauds another person by false pretenses commits a second-degree felony. The moment you hear second-degree felony, it means we are talking about a very serious crime. Now, how do we know how much is the maximum for the punishment of second-degree felony? You go to Section 296 of Act 30, which is the Criminal Procedure Act. Now, Section 296 will tell you that any time that a crime is said to be a second-degree felony, and the prescribing law does not prescribe how much should be given as punishment, then in that situation, the maximum punishment that can be given to the person will be 25 years. And so, if the judge had wanted to give Agradaa the maximum penalty for defrauding by false pretenses, she would have given her 25 years in prison.
Yes, I agree that is the maximum. But some have said being first-time offender, which I don't know what exactly they mean. Would you say she's a first-time offender? Looking at the background,
well,
I guess.
From what I have heard from some of the news reports, her lawyers argued in court that she was a first-time offender, but the prosecution was able to prove that she's not a first-time offender. I understand she has been convicted before, even though it was a fine, and the prosecution was able to show that conviction document to the judge, and so the judge became convinced that Madam Agradaa is not a first-time offender. And for that matter, I think the judge has even been lenient, because if you have committed similar offenses in the past and you are given some fines to pay, and today you have come back to commit the same offenses, you know, under Section 296, the judge is even allowed to give aggravated sentencing, which means that she can increase the sentencing by a certain percentage.
You said that the judge was lenient to her. Some are suggesting that it was more or less a harsh one. What do you say to that?
Well, you see, if there is a crime and the law says that the maximum that can be given is 25 years, and it doesn't talk about the minimum, what it means is that the judge can even decide to give you 1 day, 1 month, 1 week. It's all within the law. But we are looking at someone who is not a first-time offender. You yourself have, read a number of convictions that were done against her, I think in 2022 and 2021, and so on and so forth. So this means that this person is a recidivist. When we see someone is a recidivist, it means the person is committing the same crime that the person was, tried for some time ago. So when you have someone like this, and don't forget, the judges also take judicial notice of what is happening in the country. They watch television, they see the kind of things she does on TV, and sometimes even the comments that she passes. So all of these things will inform the disposition of the judge to decide whether he or she wants to give you a minimal sentence or a maximum sentence. In this case, she has not been given the maximum. She's been given, if you like, the medium or the middle grounds, which is 15 years, because she could have been given 25 years and the judge wouldn't be wrong. So I think that the judge has been lenient with her.
Now, she did this, if we are told, or from what we are told, during a church service. What is the connection between the law and that of religious cloak?
Okay, so if I understand your question, your question is that the incident happened at church.
Yes, he only asked them to come to church and she took some offering.
Well, that is an interesting argument that I've heard people make, because when we all go to court, when we all go to church, and we give offertory, our expectation is that God will bless us when we give offertory. So in that situation, there wouldn't be any problem at all. But from what I understand, it is not just a simple issue of the church members giving offertory. Indeed, there was a promise. Madam Agradaa promised them that if you bring a certain amount of money, you are going to get a certain amount of money back. So the people did not go to the church with a heart that they are going to give offertory. They went to church with a promise that I am going to give 10 cedis so that I can get 100 cedis back. And at the end of the day, they did not receive their 100 cedis back, which means they have been deceived or they have been defrauded. And that is why I believe they went and reported the matter to the police. So I think if it was just about offertory, we wouldn't be where we are today. But in this situation, she promised them, she gave a firm promise that if you pay this amount, you're going to get this amount. And that's how come the people went and reported her to the police.
Now, let's come to her legal advisors. Do they have any ground to make an appeal? And if they do, what would it, in what shape or would it take?
The law affords every citizen the opportunity to defend yourself from criminal prosecution. And that opportunity comes in any shape and any form. It may be possible that along the trial, maybe the prosecution committed certain minor mistakes, that if the lawyers take on those minor mistakes, they can become the basis for the setting free of their client. Nobody knows. They are the lawyers who handle the case. They have the brief. They understand every petty detail that has gone into it. And so if they go and study their brief and they find some loophole in it and they decide to appeal, good luck to them. On the other hand, if it turns out that the prosecution did their work very well and that there was no mistake anywhere and, the conviction was square and perfect, then they run the risk of going for appeal and even getting the Court of Appeal to even increase the penalty. Because don't forget, you don't always go to appeal and get your penalty reduced. Sometimes you go to appeal and the appeal court can even get angry and decide to increase your penalty.
Really?
Hello?
I was asking, quite shocked that you go to the appeals court and if care is not taken, your penalty is rather increased instead of getting it reduced.
Oh, yes, it happens all the time. Like I told you, it is possible that there were some petty mistakes in the trial that can give his lawyers an advantage to be able to go on an appeal and get the sentence either passed or reduced. But it is also possible that there's no loophole in the judgment and that everything is perfect. And the Court of Appeal judges can take the view that even the sentence that was given to you was minimal. So they are increasing it. There are a number of cases that it has happened in before.
Is it possible that as we speak, she is any of the prison custodies, or for now she could be at the police station waiting to be transferred from that place to?
It normally depends on how fast the warrant is prepared. Anytime you are convicted to be sent to prison, the court registrar is supposed to prepare a warrant. It is the warrant that will give you entry into the prison. And so, assuming the court registrar was able to prepare the warrant today, then I believe she will be sent to prison today. But assuming it was not prepared today and certain things need to be done and signed and all of those things, then it is possible she could be in the police custody so that anytime her warrant is ready, she'll be transferred to the appropriate prison forum.
Does her conviction serve as any deterrent to any other person, maybe including yourself, counsel?
Well, it means that we should all be careful because sometimes we all do certain petty things that we don't consider them to be serious enough to put us in trouble. I want to believe that this is something that she's been doing almost every day in the church, and it doesn't create any problem for her. So for her, she thought it was just normal church service. But here we are, some people have reported her, and it has become a basis for her incarceration. And so it should be a lesson to all of us. Whatever we are doing, we should pause to ask ourselves whether it is consistent with what the law allows us to do or not. If it is not consistent with what the law allows us to do, we should give ourselves a break and advise ourselves from doing it.
Let me ask, what if it was not reported to the police?
She will go scot-free. I mean, once the matter has not been reported to the police, no crime. It is the people who reported who said that the woman promised us that if I bring 1 cedi, I'm going to get 100 cedis. I took my 1 cedi there and I didn't get 100 cedis. Unfortunately for her, she herself provided evidence by doing the thing on a live television. And so those who reported her had it so easy to gather evidence against her. And today that evidence has been used against her and she's been sent to prison. If nobody reported, there will be no case.
Now, how does the state come in as far as protecting, most especially, vulnerable people? Obviously, these people who may have gone to the police to lodge the complaint that landed her into the trouble, 1 or 2 among them may be enlightened. What about those who were not?
You see, matters that has to do with convincing people are very difficult to deal with by government, because once the mind is convinced and the mind decides that it wants to do something, sometimes the person might be your wife, your daughter, your mother, your brother. You will advise them that this thing, don't go and do it, it's a scam. But once they are convinced in their mind, they are not going to listen to your advice. So to answer your question directly, I have seen that Securities and Exchange Commission, Cyber Security Authority, and other state agencies have been, putting out pieces of information to advise people against some of these things. But the question is, do those pieces of information get to everybody in the country? Sometimes they post it on Facebook. Sometimes they will do announcements on television. Sometimes they will do press conference. How sure are we that this information gets to everybody? That's number one. Secondly, even if the information gets to the people, how sure are we that the people are not already convinced such that they will not listen to any other advice but to go and put themselves in the problem and get duped? And so it is not something that is so easy to deal with. I think if government wants to deal with it, government will need significant resources to be able to get people to understand that they need to refrain from some of these quick money schemes in order to avoid troubles. Otherwise, we will fight and fight and fight, but every year there are going to be more victims of such circumstances.
My final question as to the probably is more or less personal. Did she get fair judgment?
Well, to the extent that she did not get a maximum sentence and she's not a first-time offender, I think that the court was lenient with her, because you and I will agree that a lot of people go to court and sometimes the judge will hand them 20 years, 25 years, and we all ask ourselves, this guy went to steal just cassava. Why are they putting him into jail for this long years? The problem with our law is that it simply gives minimum and maximum penalties. And so within that minimum and maximum penalty, the judge can always decide on whatever be given to you. But in all fairness, I think that her sentence is quite liberal, given all the circumstances of the case.
Are you aspiring to be on the bench someday?
Not at all.
That would be good. Well, most grateful, counsel, for your time on News Night this evening.
Thank you very much.
Well, I've been speaking with lawyer Richard Niyama. He is a private legal practitioner. Obviously, that would be good. He wouldn't want to be on the bench. I'm wondering how many people he will be sentencing to some 35, 40 years in prison with hard labor. Well, News